attorney Greg Price for Mr. Jackson. I won't be reserving any time, but I do have to bring to the court's attention that there was, in this case, approximately 40 co-defendants in this case, and it has been an issue throughout the duration, and I know because I was involved in 2 separate trials with this case. The rule of law that follows the case has kind of been broken, and it's been broken a couple times, and I've noticed that, but specifically in State v. Taylor, that was an appeal that was in front of this court.
I was going to ask you about State v. Taylor.
And that citation is 2016-7953. I'd like to talk about that, but briefly, the one thing that's distinct about my case from the other co-defendants is the identification issue. If I can speak about that briefly, I'll get back to Taylor. With the identification issue, this court's routinely held, you have to identify and you have to establish jurisdiction. In this case, the state called one of the crime scene analysts, Mildred Morris, and I think that's on about transcript page 111 through about 128. Her purpose was to identify the 3 defendants. Whenever the prosecutor held up a picture of my client, she identified another one of the co-defendants. And I have to apologize, I think it was Che Riggins, but it actually might have been Mr. Taylor, because we had our trials at the same time. And then whenever she identified the wrong person, the prosecutor said, no, why don't you come down and take another look, because I think you might need to find somebody else. Mm-hmm. And I objected to that, and that became a routine objection throughout the course of the trial. They never identified my client from the witness stand. What they did was, they attempted to hold up my picture and have somebody say, yes, that's Rashard Jackson. And then at one point whenever they were introducing exhibits, the prosecutor actually handed that picture to the judge and said, Judge, you can look at this picture and then you can look at that guy and you can see if they're the same guy. And I objected again and saying, no, a witness must identify my client. And it sounds like something very routine, but it's a thread that goes throughout this transcript. And I think the state points to transcript about 283 to 285, there was another exchange, where specifically they said, was Rashard Jackson? I said, no, objection, he cannot identify him because there is nothing. You're identifying a picture, that's not what you have to do. You have to have somebody on the stand go, that is Rashard Jackson. Now,
but I need to go back if you don't care.
No worries.
After the crime scene analyst misidentified him, I know you objected, or whoever objected, there was an objection. Oh, you said you tried it, right?
Yes.
Okay. So you objected. And then she did, in fact, then identify.
Correct.
So it's kind of like a misidentification type scenario that we would have in other cases too, where they kind of rehabilitated.
And I think you can draw a line in rehabilitation. I can say, hey, could you take another second look at this? But whenever my client's a 300-pound black man, and you point to the other 300-pound black man, and then
Maybe
he
she
says,
was just nervous. Maybe she misspoke.
well, she got down and said, well, I couldn't see him. Well, then in cross-examination, it's also clear he's less than 6 feet away from you. He's standing right there. You've been doing this for 20 years. You didn't understand that you were supposed to look at all these people, and you just looked at the first man you saw. But even at the same time, whenever she says, that's the man right there, and then the prosecutor says, basically in changed terms here, but he says, no, it's not. Won't you take another look? That's not identification. And then whenever you have preceding witnesses that can do the same thing, and the state just doesn't take advantage of it, I think that's where you can draw the line and say, look, you've had several witnesses, several opportunities, you just didn't get it right. That's the problem. So whenever you're talking about rehab, yes, but at a certain point you got to say, where do you draw the line?
So you're saying it wasn't credible?
I don't think it was credible at all. I think she simply pointed to the other guy. Because there was 2 large black men, 1 skinny black man. And it's not that one, and here's the picture. Which one do you think it is? And I'd ask the court to draw a line somewhere. I think that's where you have to draw. But I think the more important issue here is Taylor. And in Taylor, my co-counsel during that trial, one of the issues was, we came before the court and said, look, this statute's unconstitutional unless it's read one way. And I think the 11th district addressed this. It might have been the 10th. But they addressed it and said, look, this statute clearly says, pay admission or be present at a dog fight. The issue becomes, and I think the other court of appeals made it quite clear, you cannot find somebody guilty simply for being present. It's a violation of your right to assemble. You have to have had an affirmative act. You had to have done something illegal in order to be convicted of this case.
Wasn't there circumstantial evidence in the record that he paid to get into the inside of the gate?
And not my client. And I have an issue with that, but here's the issue with Taylor. I can't get to that. That issue is not up on this appeal. And the reason is exactly what you pointed out in Taylor. Whenever I was analyzing this case, I won that argument. The trial court said, yes, we're gonna read it the way you want to. So therefore, if I brought that argument, I wasn't prejudiced. And that's exactly what you said in Taylor. You weren't prejudiced.
Well, that'd be like saying, anybody who goes to a dogfight, as long as you pay, you're good. If you have a dogfight, just don't pay to go watch it. But the dogfight's the illegal thing that you're present at.
The dog fight would be illegal for everyone that brought a dog, everybody that participated in a dog, everybody owns a dog, everybody holding the event. But if I go to a house and there's a dog fight over there next door,
Well, but if you're watching the dog fight, or the dog fight is pending and you're there to watch a dog fight, it's just in between bouts, whatever they call it.
and that was the argument. That was the argument that started this whole trial. Everything pinned on that one question. Everything, all 40 co-defendants, we had pre-trials, everybody wanted to know that answer. That's not why we're here today, because I couldn't bring it, because I wasn't prejudiced. But in Taylor, what this court did was take up Mr. Taylor's argument that that decision should have been made at the beginning of the trial. Because the trial court, whenever we came in and said, Your Honor, there is one question. We don't have any other questions. How are we going to interpret this? And the trial court said, I'm not going to do that. And we explained that's really all you have to do, because there's not a lot of argument about being present. I have a whole lot of argument about whether or not he paid to be there. And the trial court said, I'm not going to answer you, and I don't have to. So we had an entire trial without him even ruling on the motion. Whenever we did our Rule 29s, that's when the court came out and said, here's how I'm going to interpret this. You have to prove that he paid to be present or gave something of value for the dogfight. So that means my client has to have come to the dogfight and paid admission. That's how the trial court ruled. That's fine with me. I can't possibly be prejudiced by that, because that's what I was arguing. But whenever this court put out the Taylor decision, the court then analyzed the constitutionality of the dogfighting statute and said, no, that's not the proper interpretation. The proper interpretation is where you were going, which is, if you're just there, if I'm in a room and there's dogfighting over there, you're guilty. Well, if that's going to be the interpretation, it really binds my ability to argue that that's not what should have happened. It also makes it possible for me to come in and say, look, if you're going to do that, that's an unconstitutional interpretation of this statute. Because it is in my co-defendant's case, it absolutely binds me with that ruling. And since it was after my briefing, I don't have any way to address that now. And that's my concern. I don't know whether to come forward and ask. And I heard about this case a couple weeks ago. I called the magistrate, figured out which one it was, read it yesterday. It's almost, I really want to ask for it to be reopened for briefing. It's that significant. Because my client, if you're going with that interpretation, it should be remanded, because my entire strategy completely changes. Because I did not introduce evidence specifically of where my client was and specifically of what my client was doing for that reason. Because they had no proof that he paid to be there. My client was asleep in the house.
Well, they all threw money up in the air.
No, not my client.
But I'm just saying.
There were people, absolutely. If you get arrested with, and I talk to people, if you get arrested for $1,500 in cash in your pocket and you're at a dogfight, don't come to me and tell me you weren't gambling. Don't tell me that you weren't participating. Don't tell me that you didn't know what was going on. But my client was arrested asleep in the house, period.
And that's what I was gonna say, because you still have a mens rea requirement,
You
even
do.
with being present.
You do.
Be present.
And that's where it comes into being present. You have a house that's filled with marijuana, my client's asleep in the house. I would be more than happy to go in there and argue, look, my client's high, he came there for pot, he's asleep, I'm sorry. And with the court's interpretation as it's laid out in Taylor, that's the argument I would have to make at the trial. Have to. Because I'm stuck with him being there. But why he's there in the mens rea of him being there is completely different than if you have the tradition or the interpretation that the trial court took, which was you have to prove that this man paid something. Now,
What if somebody else paid for it?
okay, you're stuck. If somebody comes in and testifies, said it was $75, he had 50, I gave him $25, done. All right, I paid for him, done. If I gave him a free pass and said, come to my dogfight, and he shows up, is that ticket worth the value? Yes. There's a strong argument for it.
Well, okay, hypothetically, if the charge was $75, but half people came in and didn't pay anything, didn't they all get a $75 value even though they didn't pay a thing?
No.
can't
think,
watch a $75 dog fight.
no, well, that's not true either. Because whenever they showed up, they came through a fence to get in to,
Right.
and everybody called it a compound. That's not where the dog fight was. Much like my client being in that house, that's not where
It
the
was
party
in the
was.
grass, right.
It was in that door. If you walk through that door, you will see a dog fight. That was the testimony. So, again, now we're getting into my manifest weight argument, which I can no longer make because of the decision that came down at Taylor.
But you're saying your whole case was tried on value.
It was tried on value. And now that I come here to argue that my client, there was no proof that my client gave anything of value, I can't. Because it's no longer appropriate after the decision of Taylor. So I'm really shackled whenever it comes to my arguments. That's why I went with the identification. Taylor didn't affect my identification argument. But Taylor, it cuts out every other argument that I have. And I really can't make another one. What would really be appropriate, or what I would do if I had known about Taylor before filing this, what I would bring up the argument that, one, the trial court did err in not telling us about this, because now it's not in our favor, and I am prejudiced by that. And two, the manifest weight doesn't show that my client was present, because I would be able to introduce evidence that he wasn't in the compound area, and he wasn't in that garage, he was in that house that has a separate front door. He never had to go through that gate. And if I had known that, and I had known this interpretation laid out in Taylor, I would absolutely have put that testimony. But now we're stuck.
And I appreciate what you're saying, but I guess what I'm thinking, the wheels are turning in my head very slowly maybe, but they're turning in my head, and I'm thinking that this happens, has happened in the past, when we have intermediate rulings that are different than what the trial court, that's the whole point. So I think there's probably other mechanisms and other vehicles that an attorney can look at in regards to those. But at any rate, I'm not sure, I guess my point is, I'm not sure how you're any different than anybody else when this happens to.
This is specific to this case. I don't think this happens a lot, because how this issue came up was rather sua sponte for the court. Whenever Mr. Taylor brought up the appeal, he said, look, this is wrong because the trial court did not give us a decision on this until the very end. That is wrong. And this court said, no, it's not that wrong, because you weren't prejudiced. That's the end of that argument. You have to prove your prejudice. You presented nothing. That argument's done. But the trial court said something, and here's why the trial court was wrong. Here's what it really is. The state didn't appeal this. If the state had filed an appeal and said, look, we request the ability to appeal that interpretation because we think it's different. We think it should be exactly as this court laid out. If you're present, you're guilty. If the state had filed that appeal, then I would have been able to say, no, that's wrong, and I would have filed a brief and op. But in this case, it was never addressed in any of the briefs. There was absolutely no way to know that that was coming. So whenever the court did that sua sponte, we were stuck. Now, if Mr. Taylor put that in his brief, you can say, look, it was in his brief, the state replied, we made a decision, move on. But that's not what happened. And that's why I think I don't know what to do, to be completely honest, Your Honor. My wheels are turning awful slowly too, because this is so convoluted with so many co-defendants, it's hard to keep everything exactly the same for each person, especially when you get to the appellate level. In the trial court, we had 3 trials, 3 people per trial, 10 trials. That's difficult, but we're all talking and we all know. But whenever you get to the Court of Appeals and you have 30 individual attorneys doing individual things with individual decisions, it's hard to keep up with everything. And in this particular circumstance, I don't know where the court should go, because if you're going to rule on my vote, my brief, it's been gutted by Taylor and you have the identification issue. Well, then let's say I want to take this further and say, hold up, I need to appeal your interpretation of how that works. Well, your interpretation of how this should be wasn't in my decision, or it might not be in my decision. I can't appeal Taylor and how it affects my case. The only thing I could appeal would be how Taylor came about and how it affected me. I couldn't affect the holding in Taylor. And that's where I'm stuck. And for that reason, what I would ask is, I think if you're going to change that interpretation that the trial court gave, that you should remand the issue, because it completely changes everything. And if the court didn't have
the matter under advisement, we'll issue a written decision which will be known to both sides as well as posted on